her presentation, I'm going to be coming around and handing out the evaluation forms for today. There are 2 of them, and we ask that you do complete both of those for us, and please be sure to look at the front and the back because there is information on both sides of those forms. And when you leave today, and you turn in your evaluation forms, I will issue your certificate to you. And inside the red folder that you were given today is a form that's called a participant profile. Has everybody seen that form? This one doesn't have one in it. If you will take a few minutes and complete that also, what that does is give us information about the people attending our conference, and then it adds you to our mailing list so that you receive information about upcoming conferences. And we do have 2 great conferences coming up in August, which you received postcards on today, our medico-legal conference and also the conference on aging. She is Kelly Cross, and Kelly has a degree in law from St. University, at the end of the day, St. Mary's University School of Law, and she has served as an attorney here in San Antonio since 1992. She is currently a solo practitioner in guardianship law. In addition, she is the executive director of Volunteer Guardians of Texas and the president of the Elder Law section of the San Antonio Bar Association. She's also a member of the Texas Guardianship Association, San Antonio Bar Foundation, College of the State Bar of Texas, and the San Antonio Women's Bar. She is also only one of 4 Master Guardians in Texas as certified by the National Guardianship Foundation. We're really lucky to have her with us today, and obviously you heard me say guardianship several times, so that's going to be her topic. She's going to share a lot of information with us about that. So please welcome Kelly Cross.
Okay, I hope you guys can hear me. I don't believe in PowerPoints because I think I really am an 80-year-old dressed in a almost 50-year-old's body. So you'll have to look at the paper, and it's fairly technical. But as we go through this, and actually before we begin, there was a case mentioned earlier about a little old lady that actually bit her finger off. And I was on that case with APS, and it was a little lady, a very bad Alzheimer's victim, mostly bedbound. She bit her finger off, and guess what the TV people said? She was starved to death, so she went to eat her own finger. What was the truth? She really was a very big Alzheimer's victim. She did not feel the pain, but the blood scared her daughter and granddaughter and son-in-law that were caring for her. In her home, owned by her, which was great. The problem with getting her care for her Alzheimer's, because it was way above and beyond what they could do as a family. She was bedbound, and the mattress and the blankets were stained with feces and urine and pus. You can imagine the bed sores on her. But the bigger problem was the granddaughter lived in house number 2, owned by the Alzheimer's victim. So guess what she could not qualify for? Medicaid. And so therefore she was at home. Because as the daughter said, oh gee, you know, I can't throw my own daughter out and sell that house in private pay my mother in a nursing home. So there were some criminal charges. They were probably dismissed. But that was before we actually got our own little elder law prosecutor here in town. And you know, she's struggling to take all the cases that are coming by. But I wanted to tell you about that case because it was one thing that got put out to the press. It was another thing in reality of what was happening. Same thing goes on with guardianships. Boy, I hear all the time how terribly expensive they are. And in one way they are. I also hear that it's the last resort, and it is, and it should be. It should be the last thing we try to do. That's why I have, all of these other things we can talk about before we get there. But you have to have, when you're talking about the money management programs and all these alternatives, you have to have some capacity to participate. Catholic Charities just does not send a money management person over to a severe Alzheimer's victim's house who doesn't know what they're signing anymore. So there's a limit to all things that we do, and there is no limit actually to guardianships, except for you cannot put somebody inpatient for a psych hospitalization. You can't do that. That's a very big no-no. And they don't really want you to do an abortion or a sterilization on someone who needs a guardianship. And that comes from a long, long time ago. I think that makes sense to most of us. But let's start and we're going to do a very basic understanding of what other statutes are out there before you can use guardianships. And I was telling someone at lunch that I probably turn away 90% of the people that call my office for a guardianship. And I probably spend upwards between 10 and 20 hours a week giving them resources and other things to do. Now this makes my 80-year-old mother very, very unhappy because I don't charge for that. But now we have things like 211 and other places to give that person a phone number. So at least that's great. When we talk about alternatives to guardianship, one of the first things that comes up are powers of attorney. There's medical and there's financial. Has everybody heard of medical powers of attorney, financial powers of attorney? When you check into a hospital and you're admitted, isn't there one free in the little packet along with your patient's rights? Sure there is, because we still believe that it doesn't really take capacity to sign that document. And that's wrong. Now what is not in that hospital packet? A financial power of attorney. Why? Because that's the right to steal everything you own. Do people steal as powers of attorney? Oh yeah. What happens? You hardly ever can get it back. Why? They spent it as they were stealing it. I just came onto a case, the little old guy went into the hospital. They thought he might die. He had a mass in his colon. APS was on board. They were all relieved that this gentleman went to the hospital, but he had the toenails that were curled under and embedded in his skin. So they took him in, they had failure to thrive, they find the mass, they tell the loved one, look, we're gonna operate, he might die, he's weak, he's older, he hasn't had good nutrition, he looks tiny, he's been a boozer his whole life. So that next of kin, actually a step next of kin, got a financial and medical power of attorney. 7 weeks later, he no longer had a house, he no longer had any money. I managed to get the car back. But she took everything in 7 weeks. We actually cut her off while she was at Disney World, ATM outing, the last of his $47,000 in 7 weeks. What was her story? He wanted me to have it. When he died. So she was an opportunistic personality who came on, benevolently no doubt, thought he was going to die, put him in the nursing home and walked away, let him die. She did sign a DNR, God bless her, as a medical power of attorney, and then never went back to the nursing home. So, you know, this is a very powerful document, the medical power of attorney. From what I could tell from looking at this little old man, I called the cancer doctor, and he said, well, he's treatable and curable, but he's demented. No follow-up MRI, no recommendation on treatment, because he's an old guy with dementia. And I see that quite a bit. And I think that's what made me become a guardian. Because I believe even if you are demented, you can have somebody advocate for you, with you, and beside you. And I believe that man should have had the opportunity to reject cancer treatment. And he did, with me on board 3 months after his surgery with no other therapies. But let's go back to our medical power of attorney. How many people here are from APS? APS people? Okay, APS, we all want to see medical powers of attorney so you have somebody to talk to and so you can get decisions made, and that's a wonderful thing. And in a nursing home or a hospital, it's a godsend. But you know, there's some limitations to this document. They really don't want you to do ECT, psychosurgery, which I hardly see, abortion. They don't want you to practice neglect of comfort measures if someone is dying and in need of palliative care. So those are your limitations. What we do want to see is, by law, the physician certifying that this person somehow can't speak for themselves or is incapacitated to make a decision. Now here's our first issue. Incapacity, as defined in this section of the law, is different than the section of the law dealing with guardianships. So you can imagine that doctors, through going through medical school, are not learning my definition of incapacity. They're learning informed consent, which is not the definition according to this statute either. So, but somehow we want the doctor to certify in that record that we have some sort of treatment that needs to happen, whether or not that principal, the person who gave that medical power of attorney, is incapacitated, whether they object. They want a little history here. And then if there is a medical power of attorney, that's when it springs to life, when you have somebody who's incapacitated. And no offense to the doctors in the room, if there are any, but I see at this point, incapacity really means when you disagree with the doctor. So you have to be very, very careful if you're a senior citizen and you say, oh no, I don't want to have my gallbladder removed. So basically the power of attorney springs into life. Just because you have one does not mean that it is active. It lays dormant until you have a comatose person or some sort of incapacitated person, according to this part of the law. At that point in time, the medical power of attorney is supposed to come on board and make the decision as the principal would make it if the agent knows. So what's the easiest thing to think of? Well, I always go back to my brother as a Vietnam War veteran. My brother is Buy American since he was 17 years old in Vietnam. It is 100% Buy American made. He has no foreign products anywhere in his life. So if I came on as his agent, could I go out and buy him a Kia car? No, because I know him to be different. So it's the same as a medical power of attorney agent. You do what you know that person would do because you had that talk with them. If you think about, well, we talk about diabetes and amputation. Boy, I'll tell you, I wish I had a dime for every time I've been in a nursing home and I see one leg in a wheelchair. It's a lot of amputations in the elderly community. But now let's put on that you're diabetic and you have little pieces and parts taken off over the years, and you just don't want that last surgery. What is your daughter going to do who comes in and hasn't seen you in 6 months? Oh, daddy, 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 you know, I want you to live forever. If she becomes the guardian and she insists upon that operation when she knows that he said no to amputation years ago and he didn't want any more, can she do that? Only if she is the guardian. As the medical power of attorney, you cannot override that principal's desire. So if it's a medical power of attorney, so this is if you take nothing away today, guardians are not powers of attorney. On the form in the hospital or the nursing home, there hardly is a line that says guardian. It says power of attorney. The big difference is you may not override the decision of the incapacitated person with a medical power of attorney. It's a very big distinction between the two. As a guardian, I can authorize that operation. I'm supposed to do things like the medical power of attorney based on what I know from this person from talking to them, hopefully pre-incapacity, what I've gathered from them researching their life, or what they've actually written down. But the big difference is I can override their current wishes. And that does become important when you're trying to get somebody to stay in a dialysis chair and they don't want to be in there. And I've seen dialysis nurses hold people down to save their life. But at a certain point in time, you have to have either a document if they have capacity to sign one or a guardianship. We're going to kind of go back and forth the differences all the way through this thing. So basically, when you go over to, we're on page 2, the agent's authority. How do we revoke this? And this is honestly how I make a living as a guardianship attorney. The medical powers of attorney or the financial powers of attorney are revoked. But basically, if you divorce, you need to look at your estate plan and documents. Because unlike that Social Security thing, you're no longer the medical power of attorney for your divorced spouse. So that I think that's good. So the other way you want to do this, temporary guardianships may or may not revoke that power of attorney. You'll have to see language in a court order to revoke it. A permanent guardianship gets rid of a medical power of attorney 100%. Because a permanent guardianship, that's a full guardianship, is going to replace that surrogate decision maker, right? A little bit confusing, but the Health and Safety Code does write this down and for everybody to follow. One of the things you need to know about revoking is that you can be seeing pink elephants going up the wall, and no, I don't want Mary Jane to be my medical power of attorney, revokes that person's authority. So you go, well, they're incapacitated, they're insane, they're delusional. They may still revoke their power of attorney. That's how I get business in my office. Oh, my mother made me her power of attorney for financial and medical, and now she says I'm a thief, and she doesn't want me to go to her doctor's appointments with her. Well, you know, if mother goes around and tells enough people about this, the power of attorney is revoked. So you don't have to have capacity to revoke the document. That's your second important tool to take away today. Now let's say you don't have that medical power of attorney. Has everybody heard of Chapter 313, the surrogate decision maker list, the prioritized list? Everybody know what that is? Start with your husband, pops down to your adult child. The second one is the adult child of a patient who is the waiver and consent of all other qualified adult children of the patient to act as the sole decision maker. We live in San Antonio. If you can get those 6 to 10 kids to say yes to one, good luck to you, right? There's a lot of kids in San Antonio. The surrogate decision maker list, believe it or not, we all sit there, oh, Kelly, I know all about that list. Well, do you? Because I can tell you that some of our LTACs, I've had calls from the family members who said, well, they said the eldest female child is going to be the surrogate. You ever hear that? It's an old law. And more than likely you have an older nurse on board there who's tired of the family arguing, and they're just going to appoint one person. Well, it doesn't really work that way. But this surrogate decision maker law is going to get you to a lot of tough places, and it has not been amended for quite some time until recently. And what they added on was people, it's going to only apply to people in certain home and community support services and agencies, hospitals, and licensed nursing homes. So place determines, so you have to be in a particular place. It used to be hospital and nursing home. Then, you didn't need a guardianship. Your child, could come in and make your decisions in the nursing home. But what if you needed to go out for wound care? God bless the freestanding wound care hospitals. They have also made me quite a bit of money as a guardianship attorney. Why? They won't take the daughter's informal consent in that wound care hospital. And so you get this very demented person, you strap them to the gurney, you get them over there for the wound care, and that physician sends them back because they cannot give consent. So again, when you're looking at that surrogate list, it's going to be decided upon by place first. And the home and community support services, I think they're talking about the HCS and the ICF homes, where you can have a surrogate within those homes and that agency as they go through. But again, if you have to go out for cataract surgery or something like that, you may not find that this rule is working for you anymore. I see the Consent to Treat Act in doctors' offices. The last case that we did that was on the news was adult, unmarried, 46-year-old son living with aged Alzheimer's victim mother. And he took her to her treating physician. She had a terrible rash on her face. And the doctor said, well, what happened to your mother? Oh, well, she was putting Dove detergent on her face. She thought it was lotion. And the doctor said, well, what about that Aricept I prescribed? Oh, not on her formulary. Nope, can't get it. And so she gave the son did all the talking for the Alzheimer's victim, the son did everything. Until I'm sure this doctor saw it in the news that that son was running a meth lab in the bathroom of mother's house. Okay, now CPS actually has a protocol if you have children and CPS workers that go into that environment to remove the child. I checked and APS does not have a like-kind protocol. So the worker had no protocol, I had no protocol, we had nothing for the old lady. I didn't even know to look. We were just so scared that that guy was in there with her. It took 2 weeks to get her out. 2 weeks. The doctor never called APS, never smelled anything on mother, but took all direction from a son who was not the medical power of attorney. Now maybe it's a technicality, but maybe, you know, that this doctor wanted to move on. Maybe we need to really look and see what's going on in those elders' homes. They used to be able to steal their ID and get their credit and all that. And now they're just coming right into the house with them. The children are moving back home. And what you learned about earlier about the abuse, neglect, it comes right back into guardianships. Because there is usually a reason outside of mom's dementia that brings you to my office. And it's usually something very, very scary. That little old lady's 21-year-old granddaughter became her guardian above and beyond her dad, who was the methamphetamine maker, right? And by the way, it was the second time they had busted methamphetamine lab at this house. The first time he caught the shed on fire, APS was never called, but the fire department was. They never called APS. So here's an elderly, confused woman in the backyard, and they couldn't tie the meth lab with him living in the house, even though it was in a fenced-in backyard. So I never really understood that, but the APS workers are training our first responders more and more, at least they have a whole division to do that. But you're doing best interest, that's different than just making it up. So if you know they don't want amputations, if you know they don't want heroic measures, then you're going to act as their surrogate. Most of the time you're stepping into the shoes of the elder and being them in their pre-incapacity days. So, I mean, this has got some good thought to it, especially in our Texas rules. Again, we have some limits here. They don't want you to use it for ECT. They don't want you to use it to voluntarily put somebody in a psych hospital. Usually, the new law for guardianships changed a few years ago, or about 2 years ago, and said that, well, guardians can't put people, admit people voluntarily in inpatient psychs, but we can drive somebody who's homicidal and suicidal to the hospital. You know, I got to tell you, putting them in the car is just really another whole thing. This act also wants the doctor to do some extra work. And what I find normally is that's the nurse. So basically the treatment is written down, how you try to look for somebody is written down, and then how to give consent, whether that surrogate's in person or you're going to use, I call it the 2 nurse rules. They put 2 nurses on with me on the phone. If you don't have anybody, and you look at the list and it looks pretty good, the spouse, the child, the majority, the parents. This last one, the individual clearly identified to act for the patient before they became incapacitated. Some nursing homes actually have that on the admission sheet, and I think that's a good thing. So if you go in and you're clear-headed, fine, you can say, my neighbor Sandy. So that's a wonderful thing. But I see the majority of people going into a nursing home, they've come from a stroke, and now they're in what, their little Medicare days, their 20 days of rehab, and they can't write yet. And I see that nursing home doing a DNR, and all their paper and their signatures just like this. And you're like, well, they have a DNR, we're good. I also see nursing homes keeping people from these hospitalizations, or hospitals discharging incapacitated people. So let's say you don't have a surrogate on the list, and the treatment's all been done because it was life-saving, right? Now it's time, you're the nurse discharge manager for that floor, right? Time to go to rehab. You need your 21 days at Morningside or Health South or wherever it's going to be, right? But this person is incapacitated. Can you transfer them? Well, the federal law says it's a violation of patient rights. But I don't know a single person in any discharge planning areas that will not discharge. Off they go. We had a little lovely gentleman. He was retired World War II, retired sheriff, little sheriff deputy guy. He drove himself to the hospital here, got in there, went incapacitated. He was discharged to a nursing home who had him over a year. And the only reason they called out for guardianship is they could never get him qualified for Medicaid because they couldn't get a hold of his disability check through the VA. So all they did was arrange for these sources to start paying the nursing home, but they couldn't get that one check, so that they could never get him Medicaid. I went in to see him. He had already pulled out his peg tube, and somebody decided, well, he's an old guy. Didn't put it back in, right? Where's his house? Where's his dog? Where's his car? Where's all his stuff? The hospital discharge planning person didn't know. Matter of fact, the hospital garage sold his car. Dog's dead, by the way, after a year. Dog's dead. I found 2 children in his home of residence in 24 hours. Slightly estranged from those kids, as you can imagine. Again, the troubles of alcohol. But again, discharging someone who's incapacitated happens with great frequency. And if you call APS when they're in the hospital, APS isn't really going to be able to help you at that moment. You're not looking for that. You're looking for a guardianship. You're looking for a surrogate. They are safe in the hospital, let's hope. So now let's go to my favorite subject, which is guardianship. So we're now, if you're following the outline, we're on page 3. You know, another speaker said that they want people to be fearful of aging, right? Well, I have to tell, I don't think it's for the faint of heart. I think getting old is one of the hardest things that you can do. You're vulnerable. You suffer isolation and dependency that is way above what you expected for yourself. I have stopped fighting that fight. I now name the 100 cats. And I pick out my favorite APS worker that I want to have pull me out of my house one day. You know, because let's face it, you don't know what the brain's going to do. It is still a mystery organ. They are, Dr. Royal's coming this week, and oh my God, I've been a fan of his since Dilla Serena. He'd come in with Marcia and tell us their newest research on Alzheimer's and his exit interview and things that they were doing. We were all just fascinated. And that was a facility here in town where everyone from the receptionist to maintenance to everyone in the whole place was trained by a PhD RN, Barbara Harris from Arizona, whose PhD was in Alzheimer's and dementias. So they were all trained to be able to respond to the illness. And we were all thrilled to have a unique place in San Antonio for these people suffering this disease. And if you've ever, anybody been to, what is it, Callahan and 10, where that big Lowe's is? Anybody know where Lowe's is over there? That was Dilla Serena. They tore it down and they literally put up a parking lot. So we don't have that anymore. We have places that say uncommon care. We have other places for people to go, but we don't have that unique place. And Dr. Royal has told me more than once in my 10 years I've been knowing him, if I want good Alzheimer's care, I have to go to France. Well, I refuse to accept that. And so it takes all of these little lectures. You know, I don't see a lot of lawyers here today, but it takes all of this. It's an entire village. It's the doctors, it's the nurses, it's the dentists, it's the lawyers who I'm afraid to say that will do a document for an incapacitated person. It's the safe officers who come in when there's a domestic dispute, and they'll say, but Kelly, she doesn't have a problem. I pointed to a picture on the wall from 20 years ago, and she can name all those people in the picture. And that's a first responder. So that's 2008. So why the room isn't full, I don't know. Is the need there to understand this? Absolutely. And say what you will about the APS other places, but here they have a number of workers in this room learning stuff, and probably off and on all week. And believe me, their caseloads aren't sitting there for 4 other people to do that case. I know that because I have several of mine, and I'm here and they're here. That's a relief because we're both here. But let's go to guardianships. If you don't have that power of attorney, or you have said no to the power of attorney, financial or medical, you don't have a surrogate. I mean, I live 1,100 miles away from my people, You know, I mean, I might outlive them. I'm a non-smoker now for 1.5 years, maybe. But again, you know, I have to have somebody on those documents, and I've met a lot of old people who have no one. And they'll want to put me on the document as their medical power of attorney or financial power of attorney. That's just frightening if you have to resort to a lawyer. I mean, because I don't have them on my documents, you know, I have to tell you. If the patient refuses, again, treatment, even though there's a medical power of attorney, and I had a doctor call me once from the hospital, little old lady needed the gallbladder out. I mean, really, really needed this. It was medically what needed to be done. Medical power of attorney said, sure, take it. Patient said no. Was it a rational, reasonable decision? Doctor said no, it was not. Would the doctor operate? No, he would not. So you have to go and look at that guardianship statute and see how fast you can come in. And we'll go just, I know the APS workers know this, but we're going to go quickly through some terms. Applicant is a person who files. So the son or the daughter come to my office, they're going to be the applicant. They are going to get the guardianship and be the one in power and control. The elderly incapacitated person or the incapacitated adult is the proposed ward. And we're just proposing them right now. It's just a proposal. That person's later going to get their own attorney appointed 100% of the time. An attorney is appointed when there is a filing for a guardianship. Immediately, if you have an emergency guardianship, and after you have served them with a permanent guardianship, if that's all you're going to file for. So if you don't have fire, flood, or blood, and you're just going to do a standard guardianship application, as soon as I can bring you before a judge, it's going to be 11 days. And all of the stars and the moons and the suns must align for that 11 days. If you go to a general practitioner, they have the forms in their computers, but they don't know all the limits and the time thing or how to get to the judge or anything that fast. So again, it goes back into you might need a little bit of a specialist. Not every elder law attorney practices guardianships. My elder law attorney friends do Medicaid planning, right? They wouldn't touch a guardianship with a 10-foot pole. Why? It came from family law. And I did custody cases a long time ago, so guardianship was a natural lead-in. I like soap operas. I like the drama. I like the hoarders. I'm good with hoarders. I speak Alzheimer's. I'm good at schizophrenia. Dual diagnosis, call me. I have patients like Joe. But many attorneys don't. They don't want to go there. And they don't want to deal with the frustration of the child, normally an adult child, that comes to you. They're filled with frustration and ultimatums, and if this doesn't work, and I'm never going to talk to her again, I'm never going to buy her groceries. I spend 2 hours just letting that person vent. I must let the applicant vent. And then we insert the rod and build a spine on them, because this is not easy either. This is oftentimes an involuntary action where I am involuntarily taking away your civil rights, something I really believe in. I believe in your right to vote. I'm not taking away that so quickly. And while we may laugh in the hallways, I'm sure nurses do in their little nurse cubbyholes in the hospitals, it's not a very funny thing to the elder. And it really is, it's a very serious event. It's not a kangaroo court, no matter how many times you've been in one of our probate courts. It is not a kangaroo court. The people who actually practice in this area are heart and head felt about what we're doing. And guess what? We believe that it's doctor-driven. We're going to lean on medical evidence. And so how do we get to that point? Well, let me tell you, a guardian ad litem, which is your last definition, is oftentimes appointed when APS cannot get to someone, or they don't have the resources, or it comes in through the bank, and we need to get somebody out there to investigate whether or not a guardianship is needed. And a guardian ad litem can come on. And this person, generally the court order will tell you what they're doing there. They can act in the best interest, which would be filing a guardianship if one is necessary. So how's a guardian ad litem know we're not doctors? Well, that gives us a piece of paper to take to the doctor or fax to the doctor so we can get all that HIPAA information. So when we look down here, we have to have a letter in order to initiate a guardianship. We have to have a medical opinion within the last 180 days, based on a visit within the last 180 days. I'm sorry, 120 days. Why? We want something a little bit fresh. So normally an elder doesn't maybe see their doctor that often. Guardian ad litem might ask the treating physician for earlier appearance in their office, or set up for a Geriatric consult. We have very good Geriatric doctors here in town. We're very lucky because in the outskirts they don't have that. Now, do you have to be a Geriatric doctor to write this? No. There's no liability to the doctor. Doctors are not usually doing a guardianship and a medical opinion because they got a vendetta against this proposed ward, this elder. So the law shields them on their opinion. We do read these to make sure that the doctor is not just getting all the information from the daughter. Okay, so they've actually made sense by looking at the medical. And we ask these doctors to do this incredible opinion. And if you look on Exhibit A, that'll give you an idea of what we're talking about and what we want for a medical opinion. This is a very extensive list. It's my medical opinion that I have formulated over the years. And you see on page 14, 15, and 16, it's a whole bunch of information, but it doesn't have to be typed. Some courts want it to be notarized. Our judges here really don't care. Best practices is the doctor has a notary in the office, get it notarized. But what we're looking at, the law wants to know the nature and the degree of the incapacity. That's what the law wants, and that's one of those questions. They want to know prognosis. Why? Well, we don't want to do a full guardianship if they're going to come out of a coma in a couple of days. Conversely, I love University Hospital that calls in the psych people to write the incapacity opinion letters on comatose people. I just think that's funny. But so you have to have the prognosis. You have to talk about why they can't communicate that responsible decision. Is it because their vocal cords are temporarily impaired? They've got tubes down them. Can they really write? But we don't have feeling yet. So you write what you know that day, right? And it could change. That's why we have prognosis there. Medications. Do we have a medication issue where in 2 weeks from now the doctor feels that they're going to clear up? Again, we're looking to make sure that we have a biological reason for the guardianship that's not going to clear up anytime soon. And if it is, we want the doctor to say so. They still talk about the underlying condition on a diagnosis of senility. But here's our two new ones this year. They want the doctor to say whether or not there's the mental capacity to vote. And oh man, doctors really, really have strong opinions about this. They're like, well, any idiot can vote. Well, that's very negative, isn't it? I always say, well, that's the other side voting. So they also want to know about whether they can safely operate a motor vehicle. And there's a big difference here. If you never drove, and now you're 19 and you're in special ed and you're getting ready, you're taking your little driver thing, that's very different than the senior citizen who has a stroke and might be able to regain that capacity to drive safely. But they aren't there yet. So it's two different types of driving safely. And one is, I think, a big guess. So now the other thing that's on here that I think is very important is the other information. When you're looking at that, what in the world would an attorney or a court want to know? Well, I want to know a lot. I mostly want to know level of care. Do you see some kind of emergency? Do I need a locked unit? Is this person a wanderer? I don't want to put somebody in a locked unit if they're fine in assisted living. Dr. Royal talks a lot about helping us figure out what the level of care is for people. And through his research, we don't want to overly restrain someone. We don't want to take away rights that we shouldn't, right? So it's really a blending of medical and legal and just some good common sense here. But what about recovery time? Gee, this person's bad off now, but they may recover. I have represented a 19-year-old who had locked-in syndrome for 3 months and came through it. It was just the most incredible thing. But because I think she was a quad neck down from this accident, She could use her thumb and she could blink. But eventually, a year down the road, she can now stand and she can talk. Because all of her rehab was focused on mobility, they missed the fact that she had a traumatic brain injury. And so the mother's like, oh, restore her. She can handle her $6 million recovery she got from the car accident. Could she? No. So there was a big emphasis and a big neglect. So when you're looking at these letters, you know, that's something to put down here. Yes, this person might be able to regain some of their rights, but there's a traumatic and severe brain injury. I had a big lawyer, ooh, Lordy, she was like Western District U.S. Attorney and, you know, wore the $2,000 coat and pantsuit and everything. Her dad was under a guardianship and she was all miffed and wanted him to be fine and some kind of family wealth, whatever. But she said, and see here, he suffered a TBI. And I went, oh, she gets it. He has some incapacity. Because it said severe before that. She goes, oh, it's a traumatic bodily injury. Okay, keep telling yourself that. So, you know, people will read into these things what they need to when they're dealing with their loved one, and we're depending on the doctor and the nurses to give us that extra information to keep this person safe or to not overstep. Whether they are abusive or violent, I would like to know that, especially if I'm going to go in their home. Whether they have failed, you know, with home health, they have fired them. They won't allow Meals on Wheels. Why? We want guardianship to be the last thing they do. So if Meals on Wheels takes care of it for you, then that's what it's going to be. But Meals on Wheels really doesn't take a cognitive moment. But it's nice to know that they had that so that we're not running to an emergency because of lack of food in the house. Whether or not they can make routine versus complicated medical decisions. A lot of people whose children are MR, and they love doctors, and they have been trained in their ICF houses to do routine medical things for themselves. But if that same person had to sit in a chemo chair or go through 36 radiations, would they do it? Probably not. It's like the mentally ill person that you recommend Haldol. This doctor says, well, you know, we can give them Haldol. I said, what's the side effect? Well, their eyes could roll in the back of their head and stick there. Who wants that medicine? Anybody? No. So, I mean, the side effects are something else. So you look at this laundry list, and we're using this from the doctor's perspective to help us not overreach, but to be able to look at what their functional abilities are. Because that's what Guardianship's definition is based on. It's based on functional abilities and disabilities. Weighing the risk and the balances and the treatment alternatives, all of your informed consent definitions, that's not the same as this. So I had a little old lady who could tell me what her medicines were. She was a retired nurse. I love that. But she was not taking them correctly. Or the person that said, I write a check and all my bills are paid, but they can't add and subtract. 2 plus 2, 4 minus 1. So it could be that there's a hole in that ability, and we're hoping that the doctor looks at that. The new law also asks us to put down whether or not we're talking about a physical condition or a mental condition. You know, and a lot of times with a cognitive impairment, it's going to be a mental condition. But if you look at this laundry list, you know, that's what the other is for, is to add more takeaway. A lot of times you have somebody that needs to go in assisted living and they won't do that. So we have R there to change living circumstances. It also helps because in guardianships, you might just be partially incapacitated. You could do some, but not all of the tasks necessary to take care of your food, clothing, shelter, medical and financial needs. Well, limited guardianships in Texas, this is an absolute model for the nation. And then do we use them? No, not very much. Want to know why? Because the lawyer would really have to think about it. For the medical people in the room, there is a HIPAA exception. So you have that. And I gave you what that is. It's necessary to prevent or lessen a serious and immediate threat to the health or safety of that person, the public, or to a person or persons reasonably able to prevent or lessen that threat. Well, I mean, this is very, very good, because if you think about an incapacitated person still driving, right there, it just worries me. And they always tell you what? I'm only driving on Sunday, I'm just going to HEB in church, I'm only going, and they've narrowed their circle to a very tiny, tiny circle. If you ask any of the automobile clubs, they'll tell you that most accidents happen where? Within a few blocks of your own home. And so when they don't step on the gas, or they step on the brake instead of the gas, or vice versa, you know, I mean, it could be disaster. And, you know, it's very, very difficult if I'm talking to the family about safety first, and then you have a physician that doesn't want to fill this out, and that's the person that the elder is bonded to. So hopefully, you know, we're all working together. We also go into good faith and actual knowledge in order to get that through the HIPAA stuff. The other thing that you can do is you can look at the health and safety code, and without authorizing somebody's consent, one of those surrogates on the priority list can get that information from the doctor. So I'm the son, I'm the daughter, and generally you're going to get a letter from the attorney that says, hi, I represent Mary Jane, she's the daughter of Miss Hidalgo. I'm sending you this because the daughter is fearing that mom is suffering incapacity and needs assistance over her person and her finances. Would you please give us your medical opinion? And then we either have somebody trying to charge me, or we have a cooperative doctor we never hear from. When we go through this, the rest of the paper is going to tell you that we need to have due process on that elderly person. They need to be served. Don't think that those papers aren't coming for them. They're going to get the papers that say that somebody believes they're incapacitated, and hopefully it's going to have your medical opinion attached to it. Now, one of the last things I want you to do is look at the next exhibit, which is B, I think, at the very back. For those of you who work in a hospital, this is a form that I made up to send to the court investigators. We have two here. I'd be glad to give you their phone numbers and their fax numbers. This is a doctor, a nurse, a citizen, a neighbor. Anybody can fill this out. But this says, oh my God, we have somebody incapacitated in our area. And they send it in, and this is how that guardian ad litem can be appointed. If you're sitting there blaming APS for not responding quick enough, shame on you. This is your out. Send this, because now you tickled up people within that courthouse, and they are going to look at it. And I don't know why they ask about information on finances, but usually it's got to do with the exploitation case. But you can fax this. You don't have to be a doctor. You can be a neighbor. You can do it anonymously, but just like when you report abuse, oh, it's kind of hard for us to call back and then figure out what you were talking about. But I want you to know that this is a 683 letter. This is a discharge planner's best friend. This is, I think, what relieves you from that guilt of discharging someone to a nursing home that you know are incapacitated. So you can put down there where they went, you think they're incapacitated, and put the burden on someone else to look at them. Now, we went through guardianships pretty fast. I told you there is an emergency guardianship. The fastest I can get that for a family is 3 days. And again, everything has to line up beautifully. And it's rare, but we can do that. Questions?
So who do you give this form to?
The 683 letter is sent to the court investigators of probate court 1 or 2. It's up at the top is blank because you may not be from Bexar County. But this goes to the probate court if you have a statutory sitting probate court in your area, or whatever judge is doing guardianships. And so you can send those in. You can even attach the medical opinion letter to it. Both of these forms can be copied right out of my paper, over and over and over. The only thing that was really copyrighted was the article. But this is very extensive, and I think it's any discharge planner's best friend. Any other questions? Yes? Absolutely, by sending this letter, or by telling the family. You can actually call the family and say, I think it's time. I don't see your mother has a power of attorney. Anybody have one? Nobody has one. I think you need to get guardianship If you think your patient is that not safe, you can send the 683 letter and you can even phone into APS. But I think the 683 letter is even faster because you can fax it right to the court.
How long it take to get a guardianship?
It depends on what probate court you're in, but the fastest I can get you a guardianship here in Bexar County, if it's fire, flood, or blood, is 3 days for an emergency, or 11 days for a permanent. That's because we have to post, and there's some old Texas law, Judge Roy Bean law, I call it, but 10 days is the soonest you can go in.
In the exhibit A, it says that the doctor says that he's a Texas license, but eventually in the VA system, you can find doctors that are licensed in other states and still practice medicine in Texas, so it's kind of dynamic, but I don't know how you.
We usually, for BAMC physicians, that's an exclusion under another rule. Otherwise, this form was really drafted for treating physicians and our doctors, hospitals, private hospitals. But you're right, I mean, they want a Texas medical opinion. If the doctor in Oklahoma sends me a medical opinion, I can't use it. But if the BAMC doctor is from Oklahoma, I can use it. Does that help? It's the legislature. Anything else? Thank you for the opportunity to give you a little lesson on guardianships.